All right, good morning, everyone. This is Cochise County Superior Court, CR2021-00804, State of Arizona versus Sandra Finch Russell, also known as Sandy Russell. We have counsel Mr. Lawson for the state, Mr. Fidel on behalf of Ms. Russell, who is also joining us telephonically. Time set for a pretrial conference. I did receive this morning in the form of a certified mail delivery. Looks like a minute entry and minutes involving notice of consideration. I've made this clear, but perhaps at the risk of making it even more clear, the grand jury world is not a world in which I am especially familiar. We've conducted matters in Graham County by preliminary hearing exclusively for many years. And so, Mr. Lawson, maybe I turn it to you first. There's this impending sense that there's going to be potential conflict between the delivery of an indictment, if any, and the jury trial date that we have set in just a couple of weeks. Could you bring us up to speed on your end and let us know the status from your perspective, please?
Yes, Your Honor. The court remanded the matter in early February, and that had two effects. One is that there's currently no finding of probable cause, which the state believes is necessary for trial. And the second, the state was required to commence proceedings within 15 days and provided a notice from the 89th state grand jury that occurred. The state did notify the court and the parties that the 89th state grand jury was disempaneled. A new grand jury, the 90th panel, has been seated and began consideration, and a copy of the notice similar to that was filed with the court, and I understand the court has received it now. The original is on file with Cochise County, and a copy was sent to Mr. Fidel. The state acknowledges that the 90th panel began consideration beyond the 15th day provided for in the rule, but the 89th panel did begin consideration within the 15-day limit. And those facts are what they are. There was no ability for the state to extend the 89th state grand jury panel, or at least undersigned counsel was not available to. The panel, the 90th state grand jury is undertaking investigation in furtherance of some of the issues that were raised in the remand motion, and that investigation is not complete. With there being no probable cause finding at this time, but a proceeding is in place, the state believes that the rules provide that the trial should be vacated, and the state simply because there is no ability for the court to begin a trial without a probable cause finding. The state understands Rule 8 is suspended pending the remand finding. It's one of the provisions of excluding of time from Rule 8, so the Rule 8 period has been tolling. The state's position is that the matter should be continued for approximately 60 days for a status conference so that the grand jury can complete its investigation. Actually, I can request 30 days to the end of April, Your Honor. I think that's about the time that the grand jury is expected to complete its investigation. There are processes in place there that I can't go into detail, but they cannot be accelerated, and so that's the delay in the case. And there's just no way for a probable cause finding to be handed down before the current trial date of April 5.
The last time we visited, if memory serves correctly, Mr. Fidel had requested a dismissal without prejudice under the rule, and that was resisted by the state. I perhaps would benefit in understanding better why that was not something that, under operation of the rule as I read it and understand it, the dismissal is without prejudice, and that the matter would simply be effectively recommenced were there a finding of probable cause. I'm not quite certain I understand the resistance from the state standpoint. It would almost seem to be that would be something you would want because it would buy you more time. Can you help me understand, first of all, does my question make sense, what I'm asking?
It does, Your Honor. The question is, what are we buying time for? The state's position is that Rule 8 is currently suspended, and the only issue then is that the grand jury needs to complete its work and either report back that it has chosen not to return a bill against the defendant, or it has a new finding of probable cause. There is essentially we're not buying time for anything by dismissing this matter. The rules don't provide for a dismissal in this circumstance because the matter was commenced within the time period within the rules. And this simply allows for the grand jury to report back under this cause number without changing release conditions and with no issue in terms of a future motion where the defendant could claim a Rule 8 violation or a violation of speedy trial rights.
Okay, I think I understand. The concern is that they ask for the dismissal if it's granted, and then there is a subsequent indictment that they then use Rule 8 as a sword in suggesting that it has been violated. Would that be a correct understanding on my part? Trying to avoid that. That is
correct, Your Honor. That's the state's primary goal, and the state is able to offer an approximate timeline of the end of April by the time this would be complete. And I would note that the defendant was indicted and served in the end of October, so it is approximately the original Rule 8 deadline that we're working with here in terms of a date that we anticipate the case would be able to move forward again.
So part of, I guess, my concern, and this may seem selfish if not self-centered, I don't have an infinite number of trial dates to give you. I am responsible not just for this case, of course, but for the entirety of the civil docket in Graham County, as well as the entirety of the jury trials of criminal matters. And so consequently, I'm booked now for many, many months out. I'm going to have a very difficult time in being able to grant the request, even if it is granted, to postpone rather than to dismiss without prejudice. I'm not guaranteeing you that I can get it in, given what I have on my end of things going on. I have worked around this trial date for months because it's been set 4 months, and now if we're going to move it, it's not just as easy as me saying, well, we'll move it from this week to the next week and there won't be any implications. Unfortunately, that's far from the truth. So I guess I raised that concern. I believe I've mentioned that before to everyone, but I guess at the risk of repeating myself, that remains a practical concern. Mr. Fidel, on your end, I guess the question that was kind of embedded in my brain the last time I didn't raise, I just raised right now, was why would the state resist a motion to dismiss without prejudice for the fact that that would, at least from where I'm sitting, actually afford more time? Mr. Lawson's response had to do with Rule 8, flipping that essentially to where it becomes an offensive use of Rule 8 on the defendant's end. Tell me your thoughts about that in particular, because that's something I hadn't considered might be an issue.
Well, I'm frankly, Your Honor, I'm somewhat puzzled, in my view, the issue is that the rule specifically says that when grand jury presentation is not commenced within 15 days, the case is dismissed. It does not say if the grand jury begins within 15 days and then disbands, there's no longer any time limit. So to get into that debate, we've got to be reading into the rule a provision that is not there. I think the problem I have is that I think if the case is presented fairly and impartially, I don't mean to be a saber rattler, but I frankly don't see how an indictment comes back. And I think there is at least an equal chance that at the end of the grand jury's investigation, there is no indictment, that there is a no bill return. And I think it's premature to be concerned about Rule 8. I think it's putting the cart before the horse and assuming that an indictment will be returned. And I think that in all cases, and in this case in particular, we've got to take it step by step. And at this stage, the determination and the ruling that the rules require is a dismissal without prejudice. And I'm not trying to dodge the question. I just think it's really important procedurally and constitutionally that we make sure that there is a finding of probable cause before we're talking about Rule 8 issues.
So let me ask it a better way, because I guess I didn't ask it in a way that made sense. I understand that point entirely, and I believe it's actually self-evident. What I'm trying to understand, from where I'm sitting, if I were the state, I would be thinking, well, I'd rather have the dismissal without prejudice, allowing there to be more time, that effectively renders the question moot of commencement. And what does the word commence mean as opposed to completion? Is it the 89th? Is it the 90th? I think those all become moot if there's a dismissal without prejudice. The 90th grand jury then has its ability to conduct its investigation without real concern of time. I guess it sounds like, in anticipating kind of the moves on the chessboard a few moves ahead, that the state's concern has to do with if there is a finding. Of course, if there's no true bill, then we're done, of course. But if there is, does that then trigger the response on the defendant's part to say, but now there's a Rule 8 violation? I don't see how that has any legs, but I might be missing something. So assuming for the purpose of my question that there is, in fact, a true bill returned, that's the question I have, is what implications in this cause number 2021-00804 are there as it relates to a Rule 8 matter in some other separate cause number? This wouldn't, I don't believe, be in the same cause number here. What would be the Rule 8 argument? How could that even be plausibly argued? That's the question I have.
I think you're right, Judge. I think the way I understand the rule, and maybe I'm missing something, but the way I understand Rule 8, I think it would start over if there's an indictment. If the case is dismissed, then there's a new indictment. I think Rule 8 starts at the arraignment of that new, because there's got to be a new arraignment. The whole thing starts over, basically. Yeah, that's what and it'd be a 2022 cause number, whatever other number it would be assigned, would be a CR 2022 cause number, separate and distinct from this cause number, CR 2021-00804. And so that's where I'm struggling to wrap my head around how Rule 8 becomes an issue if there's a dismissal without prejudice. That's the question I guess I just wanted to make sure I had a full understanding of. Again, the grand jury process is new to me. I've learned a ton. Thank you both, Mr. Lawson, Mr. Fidel. Very knowledgeable counsel, very intelligent, very sophisticated in what you do. I've learned a great deal from you, and I can't thank you enough for that. So,
Your Honor, could I provide one last point?
That actually was going to go right back to you, and can you help me before you do? If you can just help, in my mind, like kind of close this loose end for me here, is tied up, I guess. Is if there's a new indictment, would that not spawn a new cause number, CR 2022, and would be separate and distinct? Am I missing something? Are you aware of something that perhaps makes that not be the case?
The cause number would change, but the Rule 8 time would not. So the issue that the court has with scheduling from the date of a new probable cause finding would still occur when a new matter was filed, even if it had a new case number. And so the issues then are simply just making sure that when the matter is promptly returned, there's no significant delay in getting it back in front of the court, as there could potentially be if the matter is treated as a new arraignment in terms of service and starting the process over. There would also be a need to reestablish release conditions. And as the state has filed late last week, it's clear that the defendant herself has prepared to file a public records request and begin attempting to harass by wanting my personnel file and things like that she's not entitled to in terms of discovery in this case. And so that also is not available as long as the matter is continuing to be filed in court.
Okay. I had something dropped on my desk 5 minutes before this hearing, and just in full disclosure, I was swearing in someone who's going to be serving in the United States military when it was, and so I have seen the first page and I saw what it was called. I haven't read it. I haven't seen a shred of paper on it until this very second. So this is all new to me this morning. So I guess getting back to this question, it sounds like, Mr. Lawson, you're of the view that the Rule 8 time, if there is a new indictment, would still hearken back to the original arraignment date in the CR2021-00804 matter. Did I understand that correctly?
I believe that's correct, Your Honor.
Okay. Do you have a calculation of when you believe Rule 8 is up?
Your Honor, it's currently told, and so the matter began on October, I believe it's October 25. I defer to, it's when I have it as noted, but sometimes with mail and delays that I'm calculating wrong, and my note is that was the arraignment date. October 25 to the date which was of our hearing, which was February 2, I believe is when it was. 3. The minute entry was corrected, and so in my mind it's muddled. I'd have to look it up, but it's either February 2 or 3.
3. Yeah, it looks like the 3rd.
And so I believe that gives us approximately 2 3/4 months of Rule 8 time left. And so in terms of the court scheduling concerns, which I completely recognize and are valid here in terms of the court being a visiting judge with its own calendar to coordinate and then to get a space in a courthouse, all those issues are present regardless of whether the matter is dismissed and refiled or the matter is continued on the current calendar with no trial date, which is what the state is proposing.
So you're of the belief that we still have 2 3/4 months to work with on Rule 8. I don't know why in my mind I thought we were up around the end of April. I don't have an independent calculation, so please don't take anything I'm saying as any kind of authoritative pronouncement on the subject, but somehow in my mind that's when I remembered it being.
I think that's right, Your Honor. I recall the date being April 20-something, but I think what Mr. Lawson is saying that it has been told since February 2nd or 3rd, whatever date that was, that the motion for remand was granted, so that had eaten up about 2 3/4 months, so we would have 2 1/4 months remaining whenever, if and when an indictment returns.
Okay, I see.
But it sounds to me, like the state's position is, regardless of whether the case is dismissed without prejudice or held in this kind of limbo period with just no trial date, either way, Rule 8 is in effect, but just told. And so if those two things are equal, I don't see what the benefit is of simply vacating a trial date but keeping the case pending. And I think the rules pretty clearly require dismissal without prejudice.
So, and I understand that's your position. I don't know the first thing. I had a pleading dropped on my desk about 5 minutes before this thing started. As I mentioned, I was in the process of swearing someone in to serve in the United States military, walked in here, made the phone call, saw on my desk that this was there. There's something about wanting records from Mr. Lawson's employer or something. Mr. Fidel, can you help me understand that?
I can.
To be yet another tangential issue. I'm a little concerned about where we're going with that.
Right. I do. I think the court's characterization of it as tangential is basically accurate. Ms. Russell, excuse me. Ms. Russell filed a public records request with the AG's office. Mr. Lawson filed the notice, which the court has before it, indicating that the state is not going to produce those records. That really is not a question that is before this court. There has been nothing filed by Ms. Russell with this court. Ms. Russell has not sought to use this court's authority to obtain any records. She has filed a public records request, and if that is going to lead to any kind of litigation, it's not going to be in front of this court because that's not where public records issues with the AG's office are addressed. It would be in a Phoenix court. So I don't perceive that in the notice that the state filed that the state is asking this court to do anything. It's just filing a notice to alert the parties. So so I don't think there's anything to do on that here at this time.
But does that speak to the larger question of dismissal as opposed to postponement? Again, I'm concerned that sometimes what I get is only the proverbial tip of the iceberg. I flew over the polar cap yesterday, and there was some spectacular glaciers we got to see through the window of the airplane. And the reality is this: sometimes I get the sense that there's a whole lot more bubbling under the surface than I'm aware of. But is that an issue now that is germane for consideration? Dismissal versus postponement.
I don't think there is because there's nothing. Nobody's asking this court to do anything. So whether the case is dismissed without prejudice, I don't think impacts that issue, the public records issue, because we're not asking for the court to do anything on it. Nobody is. So it's there. I do think it's a tangential thing, but I don't think it requires any action at this time or at any time really by this court.
No, I understand that it might not fall within my specific jurisdiction. What I'm trying to understand is the implication of the public records request as it relates to the question that certainly is before me of dismissal versus postponement, right, and whether this has bearing on that question. That's right. Really what I'm trying to drive home and understand better.
And I think if we were asking Your Honor to issue an order relating to that public records request, then I guess it might, because if the case is dismissed, I suppose this court wouldn't have any jurisdiction to do anything. But I think since we're not, and nobody is, I don't think it impacts it.
Okay. Mr. Lawson, on your end, what implications, if any, does this latest request have in connection with the appropriateness of a dismissal versus a postponement? I think that's where we're coming down on this issue, as at the end of the day, if we kind of boil it all down to its very essence, the essence of the question is, do we dismiss or do we postpone? And I'm just trying to find out if this public records request implicates that question in any way from your perspective.
I think it absolutely does, Your Honor. Again, as I've offered best I can without compromising the grand jury's proceedings and the confidentiality therein, the state believes that there will be action in this case either positively or negatively by the end of April. The defendant made the public records request attached in the notice that I filed in her own capacity, not through Mr. Fidel, and that the moment this case is dismissed, she would be free to make that again and then create issues through the public records process, which could percolate before any kind of response from the grand jury. And it's clearly, if you look at the nature of the matters that she is requesting in the public records request, it's clearly a discovery-based request intended to fortify her defense in a criminal matter, which is currently being contemplated by the court and the parties. Again, there's no strategic advantage to the court in dismissing this case, because if the matter is reindicted in that same timeline with a new CR number, the scheduling problems which the court has are still there. The issue then is really what changes if the matter is dismissed versus if the matter is allowed to remain on the calendar with no trial date for a status conference that's at the end of April. And the answer would be that exactly what you see here, that the defendant is intended to use other processes as a hammer on the prosecution, and that is clearly a contemplated tactic, and maybe not by Mr. Fidel because he is not the one filing it, but certainly by the defendant herself. It does strongly bolster the idea that the matter should just be continued. Rule 15 should be held in place in terms of discovery obligations, and that when the matter comes back before the court at simply a status conference at the end of what the state is requesting at the end of April, that if there is no bill or there's no indictment at that time, then certainly there's a less compelling argument to keep the matter on the calendar. There may even be a return basis from the grand jury indicating that no finding of probable cause is coming, or there will be a finding of probable cause and the matter can be set for trial at that time within the limitations of the scheduling issues we've discussed.
So a couple of things by way of thoughts on my end. First of all, if the matter is dismissed and then if there is a new finding of probable cause that would trigger a new case number, perhaps I could make the observation that you may get a different judge besides me. I'm not unwilling to take the case, but I can only imagine on both ends I've probably been equally annoying. That may not be a strong enough word, and no one has to comment on that, but I don't know that either side is especially thrilled with me or what I've done and how I've done it. I've tried my best, and that's, I guess, what I can offer. So there would be at least the specter, possibly, of a different judge, and that may be to the liking of everyone.
Your Honor, I actually believe that's not the case.
Okay.
Your Honor, I believe that's not the case. I believe if it is recharged that the matter must come back to you. I don't have a case offhand, but I have gone through this fact pattern before and had the matter come back to the original judge, because essentially it is a refiling after a remand. Sure. Mr. Fidel may have a different opinion, but I believe that the circumstances which caused the disqualification or the recusal of the Cochise County bench, to use the more accurate term, would still be present, and so the matter would likely come back to you.
Well, I can understand that. What I'm getting at is that I'm not the only judge in Arizona that could help outside of the bar, or the bench rather, of the Cochise County Superior Court. So there's certainly undoubtedly far more intelligent and much better judges than me, although I do try my very best. I again point out that at least maybe of benefit to everyone. I guess the second question that I'm still not understanding, Mr. Lawson, the answer to is how do you believe, I haven't read anything in the notice, literally. It was dropped on my desk. I saw it had been filed. I saw the name of it. Mr. Fidel has informed me some things I didn't even know of. First of all, I thought I was supposed to do something with it. It sounds like it's more kind of an FYI. But I don't think I'm understanding, if there's a dismissal, how does that change the public records request as opposed to a postponement? That part, forgive me for not understanding, probably is a very simple answer to that question, but I'm not understanding the difference between that as it relates to this request. Can you just help me tap those loose ends?
And again, I would have filed it earlier, Your Honor, but it did not get to me. You'll see when the notice itself, when the request was received, and then it made its way through our public records office to me late last week, and I did turn it around and get it filed with the court, I believe within 2 days, because I needed to discuss it with my supervisor. But the issue there is the public records laws in terms of use of public records requests, or in terms of the case I cite also talks about subpoenas that were used on agencies outside of the Rule 15 discovery process, which is well established, isn't permitted. Counsel and the parties are expected to go through each other, in terms of making a discovery request on the party. The counsel has an obligation to produce matters that are within the bounds of Rule 15. And if there is some sort of material that is not produced pursuant to Rule 15, then there's a process in place for the court to rule upon it. If the matter's dismissed, that process ends. And Ms. Russell would be free to lodge public records requests and have the appropriate and have remedies under the public records law for production. And obviously, this is still an ongoing criminal investigation. It's an ongoing matter, and there's just no need for this matter to go outside of Rule 15. If there's at some point, if there is a finding of no probable cause and that the matter is closed, then there's an issue in terms of making matters available to the public through the public records law. But during what could be a brief window of a case when there is no probable cause finding is not a time for the defendant to run down and use the public records law, as she clearly intends to do. And that's what I was doing by putting that notice on file with the court. And again, the timeliness, as soon as it got to me, is when I brought it to the court and Mr. Fidel.
So is this a hole in the law then? Is this something that could be done? How is this not available to any person represented by counsel to make the request? Now, Ms. Russell certainly is far more sophisticated than our average defendant in a criminal case, being an attorney herself, but why is this not something that's already contemplated under the current iteration of laws and rules? This seems like a strategy that could be used in any given case. I'm not understanding.
I guess I'm not understanding your question, Your Honor. The case law that I cited says that a party in a criminal matter cannot use the public records request statute as an end run around the process of Rule 15. And so as long as the criminal matter remains filed, the defendant must make requests through Rule 15. And she has, the key thing there is she has to show that she has a reasonable basis and need for something at trial, that she can't use the public records law to bludgeon the state to produce thousands of pages of records that have an ancillary potential need, if any at all, on her criminal case. And if the Rule 15, if a court evaluated her request under Rule 15, she would get a small percentage, if any, of those records, and a number of them that are covered by the request have already been produced through the state's discovery obligation. The issue we have here, Your Honor, is the window that would be created by the defense choosing to dismiss, request dismissal of this matter, even though it is in a remand window, there is an ongoing grand jury investigation, and it is contemplated that it will be refiled within a short time period. And the state is requesting a short delay to allow that process to complete. If this matter gets well beyond that end of April timeline that we're looking at, then dismissal is appropriate because it may not be a matter that's coming back for filing, and the public records law may be appropriate at that time. But at this point, Rule 15 should control, and Rule 15 is only in place while the criminal matter is still pending, even if it is on hold pending with no trial date. Rule 15 would still apply.
No, that's the answer to the question. Is you say that there's a case. Again, I understand the timing, and I'm not upset about that. I'm just pointing out that I'm not prepared to intelligently discuss the matter because until I called and I saw, I didn't know it existed. So if there's a case that says that answers my question as to why this doesn't get done in every case. Apparently there's a case that says you can't. So,
Your Honor, I'm not sure what that case is. There's not a case cited in the notice that the state filed. It just cites Rule 15, and this is not a request for disclosure.
Okay, so all right, so let's do this. So, Mr. Lawson, there's a case in here. Let me flip to it. Still warm, having been printed off. So there's a case, Carpenter versus Superior Court in and for the County of Maricopa, 176 Arizona 486 App 1993. So there does.
Yes, Your Honor. And in that case, Your Honor,
hold on, one at a time though. Let's do this, Mr. Fidel. You go ahead, Mr. Fidel. Go ahead.
Sure. The way I read this pleading, what that case says is that if there is a request for disclosure and the defense believes the state has not complied, it can then take additional steps. But this is not a request for disclosure. This is a public records request.
Right, and that gets back to my question a minute ago. Why this isn't a tool used by every single person accused of wrongdoing, is to say, well, I'm now going to go ahead and proceed on a parallel track of making requests of the state. That seems highly aberrant in my experience of 22, almost 23 years of doing this full time. I've never heard of this approach. That's a minute ago I'd asked Mr. Lawson why this isn't being done in every case, because it seems like a slick way to go about it. But the bottom line, if I'm not supposed to do anything on this, I don't really want to bog down on the details of this, because I think everybody agrees, and much to my happiness and satisfaction, I don't look to have to do anything on this public records request. I may, if there's a motion to compel within the parameters of Rule 15, be requested to compel disclosure of certain documents from the state. But for now, I think it's more of an FYI. But I do have a question, Mr. Lawson. I do want to kind of tie this up here and make sure I understand correctly, is that the last time we conferred was before, I think, the date on this public records request, I think, maybe I'm mistaken, but that there was opposition by the state to a dismissal as opposed to postponement, which was more in the thought process of the state. But that was prior to the public records request. So why was there objection then? Because again, I'm still grappling with why you wouldn't want the dismissal. That seems to benefit you actually more than the accused. And that's what I'm still not understanding.
Your Honor, I disagree that it benefits the state to have the matter dismissed. I believe continuing the matter under its current cause number is in the interest of justice. It does continue the release conditions. It is the continuity of the calculation of the Rule 8 time, and it does avoid issues with getting the matter promptly back before the court. At the time, I previously objected because it was possible that the grand jury was going to be able to complete its work before the April 5 trial date that is still currently set as of today. That did change over the course of the time since we appeared last. And so now the end horizon appears to be in the end of April. And I can't offer any more detail beyond that. In terms of the basis for the objection at that time was that it was possible that the grand jury could complete its work within the time frame, and that is not possible under the current scheduling. However, there is the additional ground now, which is the issue with the application of Rule 15. Your Honor, this is not novel. It may be new to Your Honor's division. I had actually have used that motion before in several other cases. It's common in vexatious litigation in terms of attempting to bog down the state with production on multiple fronts. And so that's why you don't see it, Your Honor, is because it's not allowed. It's not something that the courts usually permit. And again, the Carpenter case involved a defendant who issued a subpoena directly to the police department, attempting to get additional records above and beyond what they would be entitled to through Rule 15. And the court came back and said, you can't do that. You have to go through Rule 15 if it's one of the agencies that's involved in the investigation. And the same logic applies here for a public records request as it would through a use of a trial subpoena. The court, in a criminal matter, wants the parties to go through Rule 15. and does not want to have parallel and ancillary litigation, which would cloud the issues that are fairly straightforward in Rule 15.
And again, the critical difference, Your Honor, is the state is talking about a situation in Carpenter where somebody used the court's subpoena power to request records. That's not what's happening here. Ms. Russell has requested through the public records provision as a citizen of Arizona, public records from the Attorney General's office. This is not a case where anyone has sought to use any authority by the court to produce any records.
So let me, I believe I've understood well what has been said. Let me ask another question just straightforwardly then, kind of as we've been discussing this. Is there a concern? There's been reference several times, Mr. Lawson, to conditions of release. Ms. Russell, as is every person accused of wrongdoing in a felony case, placed on pretrial services. Now, understanding that as with all intelligent uses of scarce resources, I can't imagine that Ms. Russell is consuming large quantities of time as it relates to supervision. I have hundreds of people on my pretrial services docket that most of which in criminal cases are using or possessing illicit drugs, and we're trying to use that pretrial service process for supervision, getting them treatment, trying to help coordinate that with counsel and the accused to try to help get them into treatment. The function is typically more to assist the person to get help as opposed to a strict type of supervision. As far as I know, Ms. Russell's been compliant. I'm, as things go, have little concern that she will comply, but there's this ancillary issue of going to Barbados for medical school. I guess I need to understand, is there a concern on the part of the state that she will leave town, go to Barbados, and never be seen from again if the case is dismissed? If that's the case, then let's lay it out right now and talk it through. And if it's not, then we won't worry about it anymore. Mr. Lawson?
I mean, I will say that the court has raised an issue in terms of the travel that I don't have a basis to conclude that if the matter is dismissed that Ms. Russell will go to Barbados and won't return. I don't have information that says that, but I would say that it is a possibility that there is an obligation to return if the matter remains filed and subject to release conditions. I would just observe that is a requirement. The state didn't object to the travel. I did ask counsel to provide her travel and return dates, and so that we do know that she's coming back. And I don't have any indication to say that she's, if this is dismissed, that she won't come back. But that becomes an opportunity available to her then that is not available to her at the current time.
Yeah, I guess that, as we've been discussing, that I have no objection. I've already signed the order. I hope you've got that. I have no objection to her going. I have every reason to believe that she will do what she needs to do by way of compliance with pretrial services, and as long as they're satisfied and she returns when she says, there's no issue with that at all. But I didn't know if that was somehow another issue. This case has an awful lot of tangential issues that have become important as time has gone on. So, Mr. Fidel, anything on that issue?
Sure. A couple of things. One, as the court knows and has mentioned, Ms. Russell is an attorney. She has every a bit of knowledge of her obligations to comply with court orders and to appear in court as required. And as the court knows, she has appeared at all of these hearings that we have conducted, and I would submit there is zero reason to be concerned that she would leave and not come back. I would also notify the court that Ms. Russell has canceled those plans to Barbados and is no longer planning on going. She does, however, have a 10-year-old daughter. She has a family. They do intend to have some summer travel plans. There may be some out-of-the-country trips, so we may be back with more pleadings requesting authorization to travel internationally. So I just want to let the court and the state know about that as we creep closer to the summer months and the possibility, at least, that the case could be around longer than the April date that we were originally anticipating.
Sure. No, and thank you for that. I think trying to understand what everyone is saying, I think one of the things that's being said is if there's a pending case, then she's under obligation to return. She's under obligation to be compliant with pretrial services, checking in, things of that sort. I wouldn't foresee an objection if she wanted to go to France or to Italy with her daughter. I would encourage that. I just got back last night about midnight, flew in from Spain. So I took my two youngest daughters, my wife and I, and so it's certainly speaking to me on a personal level that I agree with completely. But I think perhaps this more related issue of does she come back? If she's not going to Barbados for medical school, then it's probably not worth taking a whole lot more time about. So let me ask this. I had every intention of trying to get this thing one way or the other resolved today. However, if we've got 2 months and just shy of 3 months, I guess, to be more accurate, to work with on Rule 8, if I vacate the trial date, we still have the matter on the calendar for maybe the last day of April. I don't even know what that day is. What would that be? The 29th for a telephonic status conference. I'll have to check my calendar to make sure I am available then. I think I'm in jury trial, but I can use the lunch hour or maybe late morning or early afternoon to come touch base with everyone. We have an obvious outcome. If the grand jury returns no true bill and there's not going to be a finding of probable cause, then that makes the matter easy to resolve on my end and everyone's end. If that's not the case, then the question becomes, when do we set the trial? And so I guess I'm open to consideration. I imagine this will be something that won't be seen the same way from either side, but to my way of thinking, I can take the question under advisement of dismissal, just as I did in my under advisement ruling of March 9th. I have 60 days to make a ruling in any given case. I can certainly postpone it to the end of April. I understand we all want some certainty. We'd all like some closure, but this case certainly has presented its fair share of dynamics, and certainly as people assert their various rights, they have every right to do so, but can and ought to expect that those will be contested. I don't see any reason that I have to make a decision on that question today. I think that we are better served on the whole in continuing the matter forward to the 29th, and I'm choosing that day very arbitrarily. It doesn't have to be that day, maybe in the early part of May, but at least to get some clarity from the standpoint of the grand jury, and then we are able to go from there. So as I see it, that's the way I would like to proceed. It is not a final answer, and I'm open to ideas. So Mr. Lawson, on your end, I believe that encapsulates correctly what you would prefer to have happen. Did I understand you correctly?
That's correct, Your Honor, and I would, just in terms of scheduling, the state would request a day on or after the 27th of April. That should allow for the schedule that as it currently sits. And I agree with the court. A matter that was filed in March, the court has 60 days, and that would allow the court into the end of the first week of May to just keep that under advisement.
Okay, Mr. Fidel, I know that's not what you're asking for, but your thoughts. I do understand your perspective, but I'm open to ideas if you have any ideas.
Well, I just want to reiterate, Your Honor. I think to vacate the trial date rather than dismiss without prejudice violates what is required under the grand jury rules, and it is significantly prejudicial to Ms. Russell. She was indicted under a grand jury presentation that did not comply with the law. We have prevailed on a motion for remand. The law requires it to be represented within 15 days, and if not, to be dismissed. And to merely vacate the trial date leaves Ms. Russell under the thumb of an indictment that should not be there. The state could have complied with the rule, and it did not. And it continues to not comply with the rule. It requires a swift representation to the grand jury. And in the meantime, Ms. Russell, who has complied in every way with release conditions and who poses no risk for any non-compliance, remains subject to an indictment and release conditions and all of the stresses and other things that come along with being under indictment in a criminal case. So I do think there is a significant prejudice to her, and I would request dismissal as the rule requires.
So let me understand, how is there a difference in the being under the thumb, if you will, of the indictment if it's dismissed, knowing full good and well that the grand jury continues to deliberate on it by vacating the trial date and setting April 29th as hopefully a date that we'll know one way or the other? I don't see how there's any prejudice to her. There's no difference in any practical way. If I dismiss without prejudice today, she still knows full good and well that the grand jury is going to be investigating matters. To me, it doesn't seem like there's any difference at all. It seems like just a talking point, and I must be missing something because I don't see even an ounce of persuasive value to that argument. Can you help me see if I'm mistaken?
Sure. I think the most glaring example is the example of the motion to modify conditions of release that we had to file for her to travel to Barbados. Ms. Russell is trying to move on with her life. That requires her to, in that instance, take a trip out of the country to visit a potential medical school that she'd like to apply, that she was interested in attending. She has now made a different decision about a different medical school, so no longer needs to go there. But merely to go on that trip, she's got to file a public document requesting permission to travel, providing her travel itinerary, which is what the state had requested we provide, and then within days of filing that request, there was a newspaper article down in Cochise County publicizing the fact that she's traveling to Barbados, and all of these things become litigated in the public view, whereas she's just trying to live her life as a private citizen. So there are significant impacts of having a case under indictment versus not being under indictment, and that's I think a very good example of the prejudices that come along with it.
Why don't we do this? Any request for modification of conditions of release can be filed under seal. I'll grant that request. I can understand that. That again, maybe sometimes we just have to get together and talk it through, but I didn't know about that, and I can understand that. I don't have any concern in terms of that being an issue. I can see that. That's understandable. And if not careful, it gives the impression she's gallivanting around the world and kind of thumbing her nose, which is not true at all. It's not true. And so I can understand that. And why don't we go forward filing under seal any request to modify conditions of release? That should, I believe, take care of that issue. And so I'll go ahead prospectively grant that request if there is any such modification. I imagine that if there is a request, it's not going to be objected to as long as she continues to comply with pretrial services requirements, which I believe are likely very minimal in the large scheme of things. Again, the typical person I deal with on pretrial services, we're actually trying to get help for. We're trying to get them into treatment, get them into rehabs, get them into intensive outpatient. We're trying to help them kind of reconstruct their lives because they've become consumed by the lifestyle of illicit drugs. Obviously, that's a completely different circumstance that we have here. But certainly I can respect that concern, and that I'm persuaded that has value. So I'll grant that request. If you just file any request going forward to modify conditions of release under seal, I'll grant that, and then any order that follows will also be under seal. But I will overrule any objection to the proposed course of action. We'll set for April 29th. Let's find a time that works for a telephonic appearance. Everyone may appear telephonically, including Ms. Russell, provided she remains in compliance with conditions of release from pretrial services. I could make available that afternoon. I've got some time. I'm going to talk to some school kids at 11 in the morning, and I'm worried I will not have enough time to give you all the attention you need. I could do, say, 2 o'clock in the afternoon for a telephonic appearance, if that might work. Mr. Fidel, does that work okay on your end, sir?
It would. Is there a chance we could do it on Thursday, the 28th?
Let's take a look. The only reason I was trying the 29th is I'm trying to push this out as far as I can. I can do it the 28th. I can it looks like the afternoon. I've got oh no, that's a visiting judge. So I've got some afternoon time on the 28th. I don't know if we want to shoot for, like, say, 4 o'clock. What I'm trying to do is give as much time as humanly possible, because I really do want to know, are we going to have an indictment or not the next time we visit? I thought we would have it today. My mistake, and I didn't. With the trial, I guess I didn't feel like I had much choice but to get together today. But I could do the 28th, say 4 o'clock, if that might work for you, Mr. Fidel.
If we could do that, that would be better.
Okay. Mr. Lawson, does that work okay on your end?
The 28th at, you said 4 o'clock is fine with me.
Yeah, 4 o'clock. Okay. Ms. Russell, does that work okay, ma'am? Does that work okay, ma'am?
Yes. Can you hear me?
Yes, I can now.
Can you hear me? Okay, yeah. It took me a minute to get my mute off, but that works.
Okay, yeah, no, we've all been there with the panic to try to get the mute button off, and it doesn't seem to cooperate whenever we need it to do so. So many thanks. So let me just confirm that there's court availability. Madam Clerk, does that work okay from the court clerk's end of things?
Yes, that is fine.
Okay, so let's reconvene April 28th at 4 o'clock, all parties to appear telephonically, including the court, and then we'll go ahead. I imagine we'll have by then an answer kind of one way or the other, and depending on the outcome, we will either have a lot to talk about or not very much to talk about, and we'll go from there. Mr. Lawson, for today's purposes, is there anything further?
Nothing further, Your Honor. Thank you.
Mr. Fidel, anything further on your end?
No, nothing from me.
All right, many thanks. Will everyone please have a nice day. We'll visit again April 28th. The jury trial is vacated. That was set for April 5th, 6th, 7th, and 8th. That is vacated, subject to resetting depending on circumstances as they may unfold. So until then, please have a wonderful day. We'll talk soon. Thank you.
Thank you, Your
Thanks,
Honor.